jail?
Yes, sir.
All right, there are two cases here involving the same defendant. Case number 22 CR 62, State of Ohio versus Bryson Lee Rickman. And in that case, he's put on community control in 6122 for trafficking in fentanyl-related compound. And then case number 22 CR 94. And that one you put on community control originally in 6122. And that was for aggravated trafficking in a fentanyl-related compound also. Now this is a hearing on a motion to, or notification of a violation of conditions. Mr. Kirk, Dennis Kirk is a defendant's attorney appearing by Zoom, appearing on behalf of the state. Prosecuting Attorney Collins. Mr. Kirk, have you and your client had a chance to confer regarding the allegations? The court did notify him.
Yes, I met with him yesterday. They brought him back from the institution, and I was able to speak with him out at the jail.
All right.
And based upon my conversation with him, he is aware of his right to a hearing, does wish to waive said hearing and admit to the violations.
All right. Now, Mr. Rickman, you do have a right to have a hearing in this matter in which the state would be required to present evidence that proves you have committed these violations. You have a right to have your attorney cross-examine the witnesses for the state. You have a right to present your own evidence. In the event that it's found that you have failed to comply, one of two things can happen. I can continue your community control under the same conditions previously ordered. I can continue it with additional conditions I think are appropriate. Or the third and the most serious is that I could revoke your community control and sentence you to prison for as much as 18 months on each count, consecutive for a total of 36 months. Now, do you understand the rights that you have to a hearing?
Yes, sir.
All right. And the allegations that were filed against you, which I can't believe I let those go. I had them here a moment ago. They were filed on September the 30th. All right, it alleges that you violated Rule 7, and on 8 different occasions you tested positive for various drugs, and starting in June of 23 as recently as September of 24. And Rule 15, you failed to pay costs, and in Rule 18, you failed to pay monthly payments toward restitution. All right, so you understand those allegations?
Yes, sir.
All right. And you understand the consequences if you admit to the allegations?
Yes, sir.
All right. And with that understanding, are you admitting to the allegations as alleged?
Yes, sir.
All right. Anything from the state or probation office regarding disposition?
Thank you, Your Honor. First, Mr. Arajima advised that he would like the defendant to remain on community control and would ask the court if they would told his time while he's serving a Clinton County prison sentence and then go to treatment upon release from the prison sentence. The state does not agree with that disposition. We would ask the court to revoke the defendant's community control and sentence him to prison. Would point out that at his prior evidentiary hearing, which was on July the 7th of 22, I believe, yes, this court advised him then to complete STAR and advised him at that time that this was his last chance based on his behavior on community control.
He didn't go to STAR, did he? Did you go to STAR?
Yes, sir.
Oh, okay. All right. What is the defendant serving time for now, Mr. Kirk?
He's currently serving a sentence out of Clinton County, which is a 6-month sentence for a felony for improper handle of firearms. He was originally placed on community control in that case, and then on September 16th of this year, the same violations that were filed here, similar violations were filed there, and they revoked his community control.
Now, and that case occurred prior to this case?
I believe so, if not at the same time. The original indictment was in May, I think, of 2022 in Clinton County.
Well, there's not an allegation that it happened while he was on community control, so. Okay.
Correct.
All right, Mr. Kirk, anything you'd like to say?
We would ask the court to follow the recommendation of the probation department and perhaps consider either a STAR relapse or some other treatment. The violations here are not the most egregious in terms of they're not new felonies or offenses of violence. They certainly are serious in the fact that he continues to test positive and has a long-standing struggle with drugs. And we believe that additional time and treatment could address those issues. And since he is already serving some prison time, hopefully that would already serve as a wake-up call. If the court would select prison, would ask the court to sentence to the minimum given the nature of the violations.
Mr. Rickman, you have anything you'd like to say?
I apologize. I'm still trying to get my stuff together. It's drugs are bad. I apologize for laughing, but they're a struggle.
Oh, damn. Well, you know, given the fact that you've been on community control for over 2 years, you had a previous violation, and the court tried to work with you, and then even after that, you completed STAR, you continued to use drugs and to violate your conditions, and that simply don't do much to try to change. So, and given the fact that my friend Judge Ruddick has revoked your community control, that says a lot to me, because he and I are known for being pretty much different. Me being the strict one, him being the easy one. So when he revokes somebody from community control, that tells me that he's giving somebody an awful lot of chance too. So given that, it's a finding of the court that you are not amenable to community control, and the court hereby revokes your community control. Do we know what his jail time credit is or STAR, Mr. Arjima? How many days he did in STAR?
161 days in STAR.
161 days in STAR, okay. That also says a lot because that's a long time. So you'll be given, well, first of all, the sentence on each case, case number 62, is to a term of 12 months. And in case number 94, that's a sentence of 12 months. Those are to be served consecutively for a total of 24 months. And consecutively to the 6 months in Clinton County. The court finds that consecutive sentences are necessary because you have committed these offenses as different courses of conduct over different periods of time, and you've committed offenses in different counties, and there is clear that the one single sentence is not sufficient to reflect the seriousness of your conduct. The sentences are being imposed are not disproportionate to the harm caused. And the court feels that your history of criminal conduct and your conduct while on community control demonstrates that consecutive sentences are necessary. Now, you'll be given jail time credit against these sentences for STAR of 161 days. And in case number, let's see here, 62, you get 46 days. And in case number 94, 22 days. Now, upon completion of the prison term, it is possible that the Adult Parole Authority may put you under post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised on the terms they set, and if during that period of time they determine if you have failed to comply, they can return you to prison to make you serve an additional period of up to 9 months for any one violation, up to a maximum of half of your prison term, when it's, in these two cases, is 24 months or 12 months. However, there is a cap of half of your prison term, as I said, for all violations. But if you are convicted of a new felony, then in addition to whatever sentence a judge in a new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control, in this case, to an additional period of a year. Whatever time is left on that period of post-release control, whichever is greater, if that occurs, that must be served consecutively the sentence in the new case. You're also ordered to pay the court costs for judgment, grant, and execution is ordered. There'll be no other sanctions. All right. Is there anything further from counsel?
No, Your Honor.
All right. You're remanded to custody. All right. Christopher Burns, please. All right, you'll need to unmute there, Mr. Burns.
Yes.
Is it
All right,
unmuted?
thank you. All right, case number 24 CR 141, I'm sorry, 141, State of Ohio versus Christopher A. Burns. Present on behalf of the defendant is appearing by Zoom from the probation department. His attorney is Dennis Kirk, appearing from his office. Appearing on behalf of the state is prosecuting attorney Collins. The defendant is charged along with the co-defendant with aggravated trafficking and aggravated possession of methamphetamine. This is a first pretrial. The final pretrial is set for November 20, and the trial date is December 19. All right, I see that discovery has been provided by the state. You've received that, Mr. Kirk.
I have, Your Honor.
You anticipate any pretrial motions?
And not at this time.
Well, any pretrial motions and your discovery are due by the final pretrial. Has there been a written plea offer provided?
There has been.
All right, is your client aware of that, Mr. Kirk?
He is not yet aware of it. He needs to contact my office and make an appointment.
Okay, you hear that, Mr. Burns?
I have.
Okay, get in touch with Mr. Kirk immediately, and so you can have a discussion with him before your next pretrial. All right, anything further from counsel?
No, Your Honor.
All right, thank you. All right, this is case number 22 CR 128, State of Ohio versus Tristan Nisley. Are you Tristan Nisley appearing there from the jail?
Yes, I am, Your Honor.
All right. I'll have him on the topic. All right, Mr. Nicely is represented by Jacob Wagner, appearing from his office, appearing on behalf of the state, so prosecuting attorney Collins. The defendant was put on community control on order. No, it's not then. On September 23rd, 2022, on aggravated trafficking of drugs, trafficking of marijuana, 2 counts, and then there was a forfeiture specification. There was a capias issued on September 25th of this year. The defendant was taken into custody. Okay, well, you would think it would be there finally, maybe. Yeah, there we go. All right, so on October the 7th of this year, defendant notified the defendant, or the court notified the defendant of violations, specifically Rule 2 that he failed to report since August 2024, Rule 7, tested positive for THC and alcohol, and then Rule 19A, it failed to comply or provide documentation completing aftercare. The court notified him and then appointed Mr. Wagner to represent. Mr. Wagner, have you had an opportunity to review these allegations with your client? You're muted, Mr. Wagner.
Sorry, Your Honor. Yes, I have, Your Honor.
You're breaking up, Mr. Wagner.
Waive a hearing on the matter and stipulate that I'm in the courthouse. I'll find a new room, Judge.
Oh, you're okay now.
Okay, I'll walk over to the jury room
You're
or
good.
something.
All right. So,
We've gone over the allegations, Your Honor. He does admit to them as outlined.
all right. Now, Mr. Nicely, you do have a right to have a hearing in this matter in which the state will be required to prove that you've committed these violations. You have a right to have your attorney cross-examine the witnesses for the state and present evidence on your own. In the event that it's found that you have failed to comply, one of 3 things can happen. I can continue your community control. Additional conditions I think are appropriate. I could continue as is, or I could revoke your community control and sentence you to prison for 6 to 18 months on each count and fine you, total of for a total of 54 months, and I could fine you a total of $15,000. Now, you understand the allegations against you?
Yes, Your Honor.
You understand the right to a hearing?
Yes, Your Honor.
And has anyone promised you anything or threatened you in any way to get you to admit to these violations?
No, sir.
All right. Do you understand the allegations against you?
Yes, I do, sir.
All right. Then do you admit or deny the allegations?
I admit, Your Honor.
All right. Anything from the state probation regarding disposition?
Your Honor, the probation department is requesting that he be continued on community control and that he be ordered to enter and successfully complete the STAR program. He has a bed date available for October 30th. We would ask that he remain incarcerated until transported to STAR.
Mr. Wagner?
Your Honor, we are, I guess, shall I say, I am not specifically saying reject the STAR potential. I guess just in analyzing this case, he's been 2 years on community control. It appears, again, maybe he already caught a break from Officer Balzer, but this is his first violation with the court. I'm just speculating that maybe some of the goals that the court or probation may be wanting to achieve could be achieved through lesser restrictive means, maybe extending community control, ordering mental health counseling, things of that nature, Your Honor. But we are definitely not saying no to the STAR program. Tristan and I had a long talk about that today, Your Honor. That's all, sir.
Mr. Nicely, anything you'd like to say?
No, Your Honor. I had some things going on. I'm not going to lie. I started using again a while back. I'm not going to lie about that. My dog passed away, and it didn't really help the situation. I don't really have any excuses, but other than I messed up. And if I could make it right and prove to you guys that I wouldn't again, I'd appreciate it. If not, I'll go to STAR. I'll complete STAR. It is what it is, Your Honor. I apologize to all of you. So that's all I got.
Just as a personal note, I really detest the term "it is what it is." because how can it be what it is? How can it not be what it is? Say but it is what it is, I don't know, but that's become a popular term in our society, and I just, I can't, I'm not picking on you, I'm just making a general complaint for everybody that has to listen to me because, you know, I'm in charge. And, you know, I don't like the term. So, you know, it is what it is. You know, how can it not be what it is? If it isn't what it is, then it isn't. So, anyway, that's just a little gratuitous, unnecessary pontificating. It's the order of the court, Mr. Nicely, that you be continued on community control under the following additional conditions. First of all, your supervision is going to be extended by a period of 1 year. Second, you're going to be required to successfully complete the STAR program and any recommended aftercare. Third, you'll remain in jail until you are taken to STAR. And fourth is you'll pay the additional court cost. You'll be, as I said, remain in jail until that time. All right. Is there anything further, counsel?
No, Your Honor.
All right.
No, sir. Thank you, Your Honor.
All right. All right. Are you Travis Jones, appearing there from the jail?
Yes.
All right. There are two case numbers here involving the same defendant. The first one is State versus Travis Jones, 22 CR 90. And the second one is as a yet unnumbered. Did they give it a number? Yeah, they did give it a number. 24 CR 145, which is a proposed bill of information for fleeing and looting. All right, Mr. Jones is represented by Sarah Barger, who's appearing on Zoom on her phone, appearing from the prosecutor's office, Prosecutor Collins. Now, in case number 22 CR 90, the defendant was put on community control on November 10 of 2022 for aggravated trafficking in methamphetamine and a fourth-degree felony. Now there's a notification filed on October the 8th alleging violations of Rule 2, that he failed to make contact with probation since March of 23. Rule 3, failed to provide valid updated address since that date. Rule 7, that at the county jail on 10/8 he admitted to using meth on 10/6. And Rule 13, he failed to comply with treatment referral by Hotting County Probation. And also Rule 15, he's failed to pay court costs. And the defendant was advised of the alleged violation and was, the court had the matter set for hearing today and appointed Ms. Barger to represent him. Now, Ms. Barger, my understanding then that your client is going to go forward and enter a plea of guilty to the proposed bill of information, is that correct?
Yes, Your Honor.
All right. All right, well, let's deal first with the probation violation. Have you had an opportunity to review these with your client?
I have, Your Honor, and he's prepared to admit.
Okay. So, Mr. Jones, you do have the right to have a hearing on this case in 22 CR 90, the violations alleged for probation, and you have a right to require the state to present evidence that proves you've committed these violations. You have a right to have your attorney cross-examine the state's witnesses, and you can present evidence on your own behalf. Any event that is found that you have failed to comply, one of three things can happen. I could continue your community control under the same conditions previously ordered, continue it with additional conditions I think are appropriate, or the third and most serious is I could revoke your community control, sentence you to prison for 6 to 18 months, and fine you $5,000. You understand that?
Yes, Your Honor.
All right. Now, has anyone promised you anything or threatened you in any way to get you to admit to these allegations?
No.
All right. Do you have any questions about the allegations or the potential consequences if you admit to those?
No.
All right. Then do you admit to the violations?
Yes.
All right. Now, we'll set that aside then and go to case number 22 CR 145. Now, in that case, Mr. Jones, and actually, counsel, whenever we do a bill of information, we need a new financial disclosure statement so that I can appoint you in this case. So the deputy will get that filled out at the jail, but for future reference, I need to do that to put you on record as a counsel of record in this case. But I will go ahead, Mr. Jones, you haven't had any change in your financial circumstances since I appointed Ms. Barger a couple of weeks ago in this matter, in the other case. Have you had any change in your financial circumstances since I appointed her? Okay.
No.
All right. Well, you'll need to complete another financial disclosure form there at the jail. All right. Now, Mr. Jones, in this new case, there's a charge here that's proposed of failure to comply, which alleges that on or about October 6, 2024, in this county, you operated a motor vehicle as defined in ORC 4501.01, so as willfully to elude or flee a police officer after receiving a visible or audible signal from a police officer to bring the person's motor vehicle to a stop, and the operation of the motor vehicle by the offender causes substantial risk of serious physical harm to persons or property. Violation of section 2921.33b of the Higher Revised Code, which is failure to comply, a third-degree felony, which carries a potential sentence between 9 and 36 months and a fine of $10,000, and could also, if sentenced to prison on this case and your other case, your probation violation, by law is required those sentences to be served consecutively. Now, you've not been charged with that in this court. Under the law of Ohio, no person is required to appear in the common pleas court to answer to a felony until and unless that case has been submitted to the grand jury of the county and that grand jury has decided to return a bill of indictment. Grand jury is a group of 9 citizens from Highland County that meet periodically, usually about once a month, to consider whether evidence of certain crimes warrants them returning an indictment. They don't make a final decision, they just make a probable cause decision, and so therefore only 7 of the 9 have to vote to indict. If fewer than 7 indict, then there is no indictment, and the case never comes to the court on that, unless it is resubmitted. Now, the law does provide, however, that a person can waive or give up that right and agree to be prosecuted by way of a bill of information. And the bill of information I just read you is basically the same thing as an indictment, except an indictment is voted on by the grand jury, whereas the bill of information is simply signed by the prosecutor and assistant and is filed with the court, and then that becomes the charge. Other than that, it's basically the same. So, you understand that?
Yes, Your Honor.
All right, I have a document here, has a case name and case number on it. It says waiver of prosecution by indictment, and says that I, Travis L. Jones, having been duly informed by the court of all my constitutional rights, my right to be prosecuted by way of indictment being represented by Sarah Barger, attorney law, Hillsborough, Ohio, do hereby freely and voluntarily waive prosecution by indictment, agree to proceed in this matter by bill of information. And that's dated today, and signed Travis Jones and Sarah Barger. Now, and I'll show that to you on the camera. And is that your, I'll try to get there, so that is your signature?
Yes.
All right. So you do wish to waive your right to the grand jury consideration and proceed without an indictment?
Yes, Your Honor.
Okay. And actually, that was signed as yesterday. Today's the 17th. And I assume you got your paperwork yesterday then, Ms. Barger?
Yes, Your Honor.
All right. Now, the next step in this case normally would be to enter a plea, be arraigned and enter a plea of not guilty, and then the case would get a scheduling order. But in this case, it's an agreement that you're going to plead guilty, and I have that guilty form here. And it has your name and case number on it. And I'm going to, it's a 3-page document. I'm going to hold up the first page to the camera, and where it shows that you're going to plead guilty to that charge. Has the case number and your name. You recognize that document?
Yes, Your Honor.
Page 3, there's a signature line halfway down that says I enter this plea voluntarily. Right below that appears to be signature of Travis Jones. I'll hold that up to the camera. And is that your signature as well?
Yes, Your Honor.
And you signed it yesterday.
Yes.
When you signed this, did you understand that it was agreement to plead guilty, which means that there will not be a trial, and the next step in your case would be a sentencing hearing?
Yes, Your Honor.
All right. Now, do you feel you had enough time to fully consider this matter before making this decision?
Yes, Your Honor.
You don't feel you were pressured or rushed in any way?
No.
All right. Now, and you still want to go forward with that today voluntarily?
Yes, Your Honor.
Right now, the agreement says you're going to plead guilty to the bill of information. I just went over with you a third-degree felony. States you understand that the prison term for that could be between 9 and 36 months, or could be a fine of $10,000. There is a mandatory license suspension of at least 3 years, could be as much as life. And although prison is not mandatory, if prison is imposed on this charge, it would have to be served consecutively to any sentence on any other charge in any other court. Do you understand that?
Yes, Your Honor.
Are you facing any felony charges in any other jurisdiction besides these 2 cases?
No, Your Honor.
Are you currently on probation, community control, parole, or post-release control for a felony in any other court?
No, Your Honor.
Now, under the law, if you go to prison on this offense, upon completion of that prison term, it is mandatory that the adult parole authority put you under what's called post-release control for a period of at least 18 months, 1 year, and up to 3 years. You'll be supervised by a parole officer in the terms that they set, and if during that period of time they determine that you have failed to comply, then they could return you to prison to make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. If you commit a new felony, however, in addition to whatever sentence the judge in the new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater, and if that occurs, that must be served consecutively to the sentence in the new case. Do you understand that?
Yes, Your Honor.
All right. Now, under the law, as I said, I'm not required to sentence you to prison for this offense. I can't impose what's called community control or probation. Instead of going to prison, you'd be supervised by a probation officer in terms set by the court for a period of up to 5 years. If during that period of time the probation department felt that you were not compliant, they could file a written notice of that with the court. There would be a hearing. You'd be entitled to have an attorney. If the outcome of that hearing was you failed to comply, then at that time the court could revoke your community control, then sentence you to between 9 and 36 months of prison and fine you $10,000. And if your revocation was due in part or whole to a conviction for a new felony, then that sentence that was imposed for that new felony could also be served, or to be served consecutively the sentence in this case. You understand that?
Yes, Your Honor.
All right, now, the charge, as I read to you earlier, you understand it?
Yes.
You understand what the state is accusing you of having done and when, where, and how they allege that you did that.
Yes, Your Honor.
Have you discussed the nature of that charge, the evidence in the case, the possible legal issues in the case, possible defense you might try to raise at trial, the possible outcomes of a trial with your attorney?
Yes, Your Honor.
And are you satisfied with her advice and competence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Has anyone threatened you to make you plead guilty?
No, Your Honor.
On page 2 of this document, it says defendant shall enter a plea of guilty to the bill of information, state defense jointly recommend community control, and star. Is that your understanding of the agreement?
Yes, Your Honor.
Has anyone promised you anything other than that to get you to plead guilty?
No, Your Honor.
Now, under the law, Mr. Jones, the matter of sentence is up to the judge, not the parties. And so even though there's a recommendation to get community control, that recommendation is not binding on the court. If you are convicted of this offense, once I've heard all the information, I could decide that you should go to prison for as much as 36 months, and you receive a fine of $10,000, plus it's mandatory that I suspend your license for at least 3 years, and it could be for up to life. You understand that?
Yes, Your Honor.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No.
You have certain constitutional rights you must understand before I can accept your plea. First, you have a right to have counsel in this matter, and I appointed Ms. Barger to represent you pending your completion of your financial disclosure form. But that wasn't simply to work the case out, but to provide any defense that may be available to you under the law. And so if you decided you wanted to defend against this case instead of pleading guilty, she would represent you and defend you, including in trial, if that's what you wanted. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a right to a jury trial in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence would be presented. They'd be instructed on the law by the judge, and then that jury would decide by unanimous verdict, meaning all 12 have to agree, on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning instead of a jury, it would be the judge would hear the evidence, the judge would apply the law, the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a right to confront the witnesses against you open court and to cross-examine them through your attorney. What that means, the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else that's present. After the prosecutor's done asking questions, your attorney will ask questions. It's called cross-examination. The purpose of that is to bring out evidence would help your side of the case. You understand that?
Yes, Your Honor.
Now, under the Constitution, you're presumed innocent of this, or you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can. It's your decision. Decide not to testify. The fact that you did not testify cannot be used against you in any way by any person. No one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because it is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Right, you do have a right to use the power of the court to compel or force witnesses to testify on your behalf, the same as the state. And what that means is that if you have witnesses you want to testify that you're not certain will come in voluntarily, it's your request, the court issues a court order, subpoena that forces people to come to court to testify if you want them to, even though they don't want to be here. You should understand that.
Yes, Your Honor.
Now, under the Constitution, you are presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charge. So, you are not required to try to prove you're not guilty of this offense simply because you've been accused. In fact, under the law, at trial, you don't have to put on any evidence at all in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
Right now, originally you entered a plea of not guilty. Well, no, you haven't entered any plea yet. So under the law, if you did plead not guilty, you would deny the allegations in this charge, deny you committed any crime, and then you would exercise all those rights I've just described. Now, if you decide to plead guilty through this plea bargain we're going over, then that's the opposite of the not guilty plea. The guilty plea admits the allegation, and the charge admits that it's a crime, that you committed that crime, and that plea waives, gives up all the rights I've described for you, except the right to have an attorney, which you always have no matter what your plea. But with that exception, Your plea of guilty would waive or give up your right to a jury or court trial, waive or give up your right to confront witnesses against you and cross-examine through your attorney, waive or give up your right to use the power of the court to compel witnesses to come to court to testify on your behalf, the same as the state. Would waive or give up your privilege against self-incrimination because you're the one saying you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It waives or gives up any right to file an appeal you think you may have had up to this point in the case, although if I do sentence you the maximum sentence or under the limited circumstances, you can file an appeal. That would have to be filed within 30 days if you're sentenced in an intervening file. And finally, it would subject you to being sentenced immediately by the court. Do you understand all of that?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
All right, now, do you have any questions, Mr. Jones, about the charge or the possible penalty?
No, Your Honor.
You understand it?
Yes, Your Honor.
And you understand the process which you're before the court on this case, which is through waiving indictment and agreeing to be prosecuted by a bill of information?
Yes, Your Honor.
All right. You have any questions about the plea agreement?
No, Your Honor.
And again, you understand the recommendation is to sentence is not binding on the court.
Yes, Your Honor.
You have any questions about the constitutional rights I've explained?
No, Your Honor.
You understand those?
Yes, Your Honor.
All right. And now, do you have any questions you'd like to speak with your attorney about? If you do, I can put you and her into a breakout room where no one else will be able to see you or hear you.
Yeah, I got a couple questions I'd like to ask her real fast.
All right, I'll put you in the breakout room. The deputy will step out while we're doing that then. Can you text JD and tell him to come in? We'll do Mr. Kirsch real quick.
Yes, Your Honor.
Well, wait a minute. I thought I had,
You sent it to me, Judge.
uh-oh. Well, that's what I tried to get. All right, I'll just have to close that and redo it then. For CR 96, State of Ohio versus Robert Kirsch, L. Kirsch Jr., President on behalf of the state's Assistant Prosecutor King, President on behalf of defendants, Attorney Jacob Wagner. You are Robert L. Kirsch Jr.
Yes, Your Honor.
All right. This is back for a status hearing, pre-trial / status hearing, and jury trial set for the 12th. What's the situation? What's the status of the case, counsel?
If I may, sir?
Go ahead.
Yes, Your Honor, my client, I did report yesterday for the polygraph. I haven't had this happen often. It came back, I guess, I don't know if we stayed on the record or not, inconclusive. Did not make a finding either way. Myself, Mr. King, and Ms. Collins have had various discussions. We think this case will be resolved on Monday, hopefully, Your Honor.
We'll resolve what?
Itself on Monday. We've got some things in the works, so just go ahead and leave it on the...
All right. Okay. Stay in touch with your attorney then, Mr. Kirsch, and if we get another hearing date set, he'll notify you. You'll need to come up then.
Okay, thank you, Your Honor.
All right, thank you. All right. Case number 24, CR 140, State of Ohio versus Joey R. Fender, present on behalf, this is a hearing by Zoom. Ms. Fender is appearing from the probation department. Her attorney is Jacob Wagner, appearing on his phone by Zoom. Appearing on behalf of the state is Prosecutor Collins. Defendant is charged in a 6-count indictment. This is the first pretrial. Final pretrial is November, I think, the 20th, and the trial date's set for the 19th of December. All right. I see that the state's provided discovery, and you've received that, Mr. Wagner.
I have in an offer, sir.
All right. Do you anticipate any pretrial motions?
I do not, Your Honor.
All right. Your discovery will be due by the final pretrial, and is your client aware of the offer?
She is, sir.
All right. Are there any other matters we need to discuss at this time?
Not from the defendant.
Not from the state.
All right, Ms. Fender, just keep in touch with probation, your attorney, and we'll see you at your next pretrial. Thank you.
Thanks, sir.
All right. Who else do we have there at probation is... Okay, this is case number 24, CR 122, State of Ohio versus Tara R. DeHaas. You're Tara DeHaas appearing there from the probation department.
Yes.
All right, Ms. DeHaas's attorney is Danielle Witt, appearing by Zoom from her office. Appearing from the prosecutor's office is Prosecutor Collins. Defendant is charged with aggravated possession of methamphetamine, a 5th-degree felony. This is the first pretrial. Final pretrial set for November 6th, trials December 9th. I see the state's provided discovery, and you've received that, Ms. Witt?
I have, Your Honor.
And the bill of information?
Yes, I have.
All right. Now, your discovery will be due by the final pretrial. Now, do you anticipate any pretrial motions?
I did file a motion for treatment in lieu earlier today.
Oh, okay. All right. Have the stipulated questions been filed yet?
No, I do need her to get with me so that we can do that.
All right. Ms. DeHaas, when you get done, why don't you walk down to Ms. Witt's office, and there's some paperwork you'll need to sign, and you can make an appointment to do that, okay?
Okay.
You know where her office is, right?
Not entirely.
Just north of the courthouse, on the same side of the street, just past the old firehouse.
Okay.
All right. All right. Anything further from counsel?
No, Your Honor.
All right. Thank you.
Thank you.
All right. All right. Case number 24 CR 116, State of Ohio versus Just Alexander Brooks. This is pre-trial. I'm present on behalf of the state's Assistant Prosecutor King.
No, Judge, this one is
Oh, I'm sorry, Ms. Collins. Mr. Chandler, I don't have any video on you.
I can hear you, Your Honor.
Pardon me?
I said I can hear you.
I didn't say, apparently not. I said I don't have any video on you. Can you turn on your video?
I don't appear on it, Your Honor, but I can hear and I can see you. I can't get my camera working.
Okay. Well, Mr. Brooks, as I understand it, is in Fayette County, and I noticed that we noticed you on this hearing, but I don't have you as has entered an appearance in the case yet. Are you actually representing Mr. Brooks?
He has not retained me yet, Your Honor.
Okay, well then you're not counsel of record, so then you're off the hook. And the matter's going to be continued due to his incarceration in Fayette County. And we'll have to make arrangements to do that. And we won't notify you anymore unless you enter an appearance. So.
I will do so. I'll contact the family, Your Honor, and I'll enter appearance if I'm going to do it. Thank you.
All right. Now, speedy trial time will be told due to the defendant's unavailability, and we'll put on an inactive docket until we can see when we can get him back here. All right. Thank you.
Thank you.
Yeah.
Chief Renner mentioned that this is having trouble getting back in, it's just spinning. So I don't know. What's with you?
Well,
It's not working.
you're going to have to turn your phone off because we're still on. I'm not getting any. The jail's not coming back on either.
Did she break it?
Huh?
Did she break it?
Yeah, you broke the internet.
We may have looked well.
I still got everybody else here, so I don't know what's going on. All right, well, let's go ahead and do, let's see, do you have Mr. Ducker?
Yes.
All right, let's do Mr. Ducker since he's here, and call out to the jail after I start this and see if they are having problems. I hate to have to turn it off and restart just.
On the record,
All right, this is case number 24-CR-108, State of Ohio versus Richard Ducker. Present on behalf of the state is Assistant Prosecutor King. Present on behalf of the defendant is Attorney Sarah Barger. And are you Richard Ducker?
Yes, sir.
All right, now the defendant has entered a plea of guilty to receiving stolen property, a fourth-degree felony. The matter was set for sentencing today. Mr. King was the victim of the offense, notified of the time, place, and purpose of this hearing, the right to be heard.
Yes, she's been notified, Your Honor. She's not present. However, she has prepared a statement for the victim advocate to read at the appropriate time.
All right. If each of the parties had an opportunity to review a summary of the PSI.
State has, Your Honor.
Yes, Your
All right.
Honor.
Mr. King, on behalf of the state.
Thank you, Your Honor. The state would just ask that the court follow the joint recommendation and place the defendant on community control. This would be a House Bill 86 case as he has no prior felonies. Finally, the restitution in this case is $250. And that comes from a tow bill that the victim had to pay. That's all I have, Your Honor. Now, if the court would permit the statement to be read.
All right.
On September 5th, 2023, I lost a dear friend and father to my girls. His name was Thomas Mason. It has been a heartbreaking time for my family, struggling with the loss of someone so important in our lives. Amidst all the grief over this past year, I was left being the executor of his estate, trying to handle everything when I live an hour away from the property. Not once, but twice, thieves invaded the property, stealing numerous things that Tom worked so hard for. Tom's wishes were for all of his things to be sold and the money provided to my girls for their needs. One of the thieves, I believe to be Richard Ducker, as we have him on security camera on the property, walking back and forth from one of Tom's cars, the Impala, which was also stolen, which is what the charge is about today. Not only did I have to drive an hour and a half to pick up my stolen car, but also pay a $250 tow bill to retrieve my stolen car. I recommend the highest sentencing possible to Mr. Ducker. There is one thing I cannot stand, and that is a thief. My whole life I have worked so hard to support my family. Tom was a good man who stood by my side through thick and thin, and he wanted his girls to have these things to be able to have extra cash. As my youngest just started college in August, Mr. Ducker took those things away. What makes it even more sickening is to find out that he is the son of Tom's brother Dan's girlfriend. So he knew Tom, and he took advantage of his death by stealing from Tom's estate. Please make sure justice is served. Thank you, Pamela Weary.
Anything else?
No, Your Honor.
Ms. Barger, on behalf of the state, or the defendant.
Your Honor, Mr. Ducker has had a heck of a year this year. He is trying his best to comply. We would just ask that the court grant community control and give him that opportunity to comply with the community control regulations. He has admitted that he has a problem, and he is attempting to take the steps to correct that at this time.
All right, anything you would like to say, Mr. Ducker?
I'm very sorry for it. I mean, there is nothing, you know, not much I can say. You know. I don't know, I'm at a loss for words. I apologize.
All right, well, it's the order of the court that you be and are hereby sentenced to a term of 3 years of community control under the supervision of the probation department under the following conditions. You obey all laws of all jurisdiction, conduct yourself in all body and manner at all time, report when and as directed. You're to be truthful in all statements you make to probation regarding your supervision. Just keep them informed of your residence, place of employment at all times, when it may not change either without prior permission. May not leave the state of Ohio at any time without prior written permission. May not enter upon the grounds of a correctional facility without prior written permission. You may not purchase, possess, own, use, or have under your control any firearm, ammunition, dangerous swords, weapons of any other type. You may not purchase, possess, use, or have under your control any controlled substance, drug of abuse, CBD oil, kratom, or any variant or analog of any controlled substance has effects similar to those, nor may you possess an instrument, device, or thing that may be used to administer or prepare them for administration unless you have a lawful prescription for both the device and the substance. You submit to drug testing when and as directed. Not to purchase, possess, use, or have under your control any alcoholic beverages or be present in places where they're sold or being consumed, even if otherwise lawful. Not to associate with anyone who has a co-defendant in this case, a criminal record, a member of a gang, or any person who has in the past or could in the future to influence you to commit a criminal offense. You may not, after the date of this order, marry or establish cohabitation in a common law marriage type relationship with another without written permission. You must report any contact with law enforcement or arrest, citation, conviction, or other charge of violating law not later than the next business day after that occurs. Provide your supervising officer a financial information record so your ability to pay any fees or costs can be reviewed. Call out the jail. Tell the sign right there. There, left. Oh, I'm sorry. Okay, there they are. I did see them a minute ago. All right. You will be, if you're referred for a evaluation assessment for any further treatment beyond that order by the court or any other kind of programming, you'll submit to that. Programming is indicated, you'll enroll in and follow that, complete it successfully. You'll provide your financial information and records to the probation department so they can review your ability to pay your cost and your restitution. So you will be required to pay that restitution, and one of those things will be that you'll need to seek work. Now, you'll be required to pay the court costs of this action, make payment arrangements to do that. Are you working now?
No, not right now. I'm trying.
All right. Well, you'll be required to do 400 hours of community service at the rate of 20 hours per week for 20 consecutive weeks, unless you get a job where you're working at least 20 hours a week. or you have documentation you're not able to do that. You'll be required to pay your restitution in monthly payments of $25 beginning December 1st, and every month after that. Now, by being placed in community control, you're deemed to have consented to a search without a warrant of your residence, your vehicles owned by you or used by you, or any other property place where you're found or what's under your control anytime any officer of the probation department. Now, in the event, by being placed on community control, you're deemed to have consented to a search without a warrant of your person. Well, I already said that. Now, in the event that it's alleged that you have failed to comply, the probation department will file a written notice with the court. You'll get a copy. There will be a hearing. If the outcome of that hearing is you fail to comply, then at that time, the court can revoke your community control and sentence you to prison for a period of between 6 and 18 months and fine you $5,000. If your revocation is due in part to a conviction for a new felony, and you're sentenced to prison for that offense, then that sentence could be ordered to be served consecutive to any sentence imposed in this case. It's also, I'll look at something else here. Now, if you fail to make your court cost payments, then the court could order you to do community service and give you credit in any charge of work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, in the event that the court revokes your community control and sentences you to prison, upon completion of that prison term, it is possible the adult parole authority will put you under post-release control for a period of up to a period of 2 years, and if during that period of time they determine that you have not complied, they can return you to prison and make you serve an additional period up to half of your prison term for one or more violations. However, if you commit a new felony, then in addition, whatever sentence a judge in a new case can impose upon you, that judge is also authorized to sentence you, in this case, to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. Officer Benson, I have here a report that it's dated today, that he hasn't been down to probation since September 17th.
No, sir, he has not.
Okay. Has he been told to report?
Yes, sir, and he was supposed to get his assessment done at the Recovery Council down in Batavia, found by Claremont, and he didn't do that as far as I know either.
All right. Well, you go right down to the probation department as soon as you get done here. You better do what you're told, because, you know, I don't have a lot of patience for people that don't listen. And for somebody who doesn't want to go to prison, I assume you don't, unless you're stupid. Nobody wants to go to prison. But, you know, you've already, got the door open here. You're not reporting even before you're on probation, and you haven't got your assessment you're supposed to be done. So that assessment, that order that I told you to undergo, you undergo that assessment. Did you undergo it down in Claremont County? Why not?
I have not. I mean,
why? You just didn't?
No, well, I called a couple places, and they told me I had to have insurance. I don't know if I called the right places. I'll be honest, like the right type of place. And then I went in there, and she finally told me to go to Batavia. And I have not called Batavia, but I called other places, and they were telling me that I needed insurance. I don't know. I'm not sure.
It's an additional condition. You're going to serve 30 days in jail. Take him into custody. That way, we'll make sure you get your assessment, and you'll be around to do what you're told, and you're now going to get the message, and I mean what I say, because you got a really bad attitude. You have failed the attitude test major league here today. You act like you don't even think that this is a big deal, and you're mistaken. All right, you're remanded to custody. All right, now, Ms. Barger, I'm going to try to create that room all over again here. So, and get Mr. All right, back on record on State versus Travis Jones, 22 CR 90 and 22 CR 145. All right, Mr. Jones, you've had an opportunity to talk with your attorney?
Yes, Your Honor.
All right. And Ms. Barger, then are we going forward?
Yes, Your Honor.
Okay. All right. Then, Mr. Jones, is it your decision to plead guilty to the charge in the bill of information pursuant to the terms of the agreement we just gone over?
Yes, Your Honor.
All right. Then, as to the charge in the bill of information, which alleges that on or about October 6, 2024 in Highland County, Ohio, you did operate a motor vehicle as defined in ORC section 4501.01 so as willfully to elude or flee a police officer after receiving a visible or audible signal from a police officer to bring the person's motor vehicle to a stop, and the operation of the motor vehicle by the offender causes a substantial risk of serious physical harm to persons or property in violation of section 2921.331B ORC, failure to comply with the order or signal of police officer, a felony in the 3rd degree, carrying a possible prison term between 9 and 36 months, a fine of $10,000, a mandatory license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, thank you. The court finds on this date open court, defendant was advised of all his constitutional rights, made no intelligent voluntary waiver of the same pursuant to criminal 11. Please accept an order filed. Defendant is found guilty of the offense. Matter will be referred to the probation department for an updated pre-sentence report. Ms. Benson, I'm going to make this one pretty quick because I know Mr. Bolton has done this one before. He can just update it. So it's going to be set for November the 6th at 9 a.m. And Mr. Jones will be held without bond until then. And we'll also set the evidentiary hearing disposition for the same day. All right. Anything further, counsel?
No, Your Honor.
All right,
No, Your Honor.
all right. I need Mr. Smith next, Alan Smith.
Very good.
All right, this case number 24 CR 107, State of Ohio versus Alan Wayne Smith. You're Alan Wayne Smith appearing there from the jail?
Yes, Your Honor.
All right, Mr. Smith entered a plea of guilty to a charge of receiving stolen property, 4th degree felony. The matter was referred to the probation department and as also to the drug court docket for reports. The defendant is being represented by his attorney, Catherine Hapner, appearing from her office, appearing on behalf of the state is prosecuting attorney Collins. And Ms. Collins, has the victim of the offense been notified of the time, place, and purposes of the hearing, the right to be heard?
Yes, and they're actually in the hearing with the Highland County victim witness.
Okay, thank you. All right. Have each of the attorneys had an opportunity to review a summary of the pre-sentence report?
I have, Your Honor.
All right. And I'll note the defendant has signed an application for the drug court docket, and I do have a letter indicating from the drug court coordinator that he appears to be eligible for the program. All right. Anything from the state regarding sentencing?
Your Honor, we would ask the court to impose a term of incarceration in this case. We would note that the defendant has, according to the PSI and the discovery, I believe, 10 prior felony convictions. I'm not sure if he's had a prior prison sentence, but I would be surprised if he hasn't got a prior prison sentence. His most recent was in 2022 for an F3 out of Florida. This is a property crime. It's not a drug offense, and while I understand that substance abuse may play a part in property crimes, Mr. Smith has left a victim in his wake. We would, based on all of that, we would ask the court to impose a term of incarceration.
All right, Ms. Does the victim wish to make any statement?
They do not.
All right, Ms. Hapner?
Thank you, Your Honor. My understanding is that Mr. Smith does have some prior convictions. They were in the state of Florida. This is his first conviction in Ohio, and I do not know if there are comparable crimes in Ohio, whether they're felonies or misdemeanors. It's also my understanding that Ms. Sturgill has met with Mr. Smith, and she does have a bed available for him at Star on October 30th. So that would just be next week. Mr. Smith has indicated both to me and to Ms. Sturgill that his underlying drug use is what led to this offense. And it's also my understanding that the drug court is for defendants with prior felony convictions who do have underlying drug problems. And so I do believe that he is a good fit for drug court. He has been accepted into the program, and we do have a bed date available for him. So we would ask that he be granted community control based upon completion of the STAR and the drug court program.
Mr. Smith, anything you'd like to say?
Yes, Your Honor. Down in Florida, the F3 is the lowest level felony they have. They only have 1, 2, and 3 class felonies. So it's an F3 in Florida is like an F5 here.
Okay. Anything else you'd like to say?
Yes, Your Honor. I am. I know I have some prior felonies, and I made some bad choice, but I'm trying to, do something different. Like I explained to Kim and Tanya, I haven't only done ever one rehab my whole life, so I'm just trying to do something but to find a different way to live. I feel that treatment at this time of my life is the best thing for me. Prison only makes you worse.
Have you ever served a prison term before?
No, Your Honor. I've never been to prison.
That's probably why you're here. I'm looking at your record, starting in January 21st of 06, you had 2 counts of fraud and 1 count of dealing in stolen property. It says you pled guilty and got 2 years probation. It says that's revoked. In Ohio, that would mean you went to prison. And then also on January 21st of 06, a possession of heroin, 3rd-degree felony. So that's 4 3rd-degree felonies. Then in March of 06, you had dealing in stolen property. You got 5 months in jail on 2 counts of that. And then in June of 06, defrauding a pawnbroker, 2 years probation. So 3, 4, 5, that's 7 felony. I'm talking, you just listen. You had your chance, now I'm talking. Then you go to June 15th of 2015, 2 counts of fraud, 2nd-degree felonies, which would be the middle most serious offense in Florida, I guess, assuming that you're correct and seem to have some knowledge of that. Guilty, it says. Doesn't indicate what the penalty was, if any. Then we have, so that's 9 felonies. Then we have criminal trespass, resisting officer, petty theft. Those are all misdemeanors in 15, 18, and 22. And then most recently in Pinellas County in 22, another fraud, F3 guilty. No indication of what the penalty was. Now, I'm sure you do abuse drugs. You probably have a situation, but when I read your report, the first thing that came to my mind, even made a note of it, is a history of cons in Florida. And you're a con artist. And I think the whole thing with getting into drug court is just another con on your part to try to stay out of prison. You've never been to prison, and that's too bad, because if you had, maybe you wouldn't be where you're at today, because maybe you would have learned something about accountability, but you didn't. I'll also say this: most people that are under the influence of drugs and operating in severe addiction don't make good con artists. And that's what you are, according to your report. Defrauding, pawnbroker, defrauding others, dealing in stolen property. Your history includes 1 drug offense, but it has multiple fraudulent behaviors. And so, I think that you've simply enjoyed I don't know why you didn't get time in Florida. You should have on many occasions. And it looks like the most you ever did, according to the report, is 5 months. And then all these others, I can't even tell that there was a penalty imposed, if there was one imposed, even though you were found guilty. So, in this court, we do expect people to be accountable for their crimes. So it is the judgment order of the court that you be and are hereby sentenced to the Correction Reception Center in Orion, Ohio, for a period of 12 months. And you have the jail time credit there, Dan. And you'll be given credit of the 61 days since you were, oh, wait a minute. That's from September. All right, so September 10th, it was 61. So we had 20 days in September, and today is the 17th. So that would be 37, that would be 98 days. All right, so you get 98 days of credit on your sentence. Upon completion of your sentence, it is possible that the adult parole authority will place you under what's called post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised under parole officer under the terms they set, and if during that period of time they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to half of your prison term for one or more violations. But if you commit a new felony, then in addition, whatever sentence a judge in a new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively sentenced in the new case. You're also ordered to pay the court costs. If you fail to do that, that can be collected by various means, including levying on bank accounts, wages, earnings, other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, once you get out, you can do community service in this county, and you'll be given credit for each hour you work and an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
Restitution out of $50 to Patricia Bishop.
Yeah, restitution is ordered to be paid to the victim, in this case of $50 to the victim witness restitution escrow account. All right, now anything further?
No, Your Honor.
All right, you're remanded to custody. Francis Jordan, please. All right, are you Francis Jordan appearing there from the jail?
Yes, sir.
All right, this is case number 24, CR 142, State of Ohio versus Francis J. Jordan II. This is a hearing being conducted by Zoom. Mr. Jordan's appearing from the jail. His attorney is Danielle Witt, appearing from her office, appearing from the prosecutor's office, Prosecutor Collins. The defendant has entered a plea of guilty to trafficking in a, he is charged with, I should say, 2 counts of trafficking in a fentanyl-related compound and 2 counts of possession of fentanyl-related compound. Now, I've been presented with a plea of guilty form, Mr. Jordan. It indicates you're going to withdraw your not guilty plea, plead guilty to count 1, a 4th-degree felony. I'm going to hand that, or I'm going to say, I shouldn't have, I'm going to put that first page up to the screen camera and ask if you can see that.
Yes.
You recognize that document?
Yes, I do.
Page 3, there's a line that reads, enter this plea voluntarily. Below that is a signature. Is that your signature there?
Yes, sir.
When did you sign it?
Yes, sir.
I say, when did you sign it?
Day before yesterday, I think.
All right. When you signed this, did you understand it was an agreement to plead guilty, which means there won't be a trial and the next step in your case will be a sentencing?
Yes, sir.
And did you go over it with your attorney before you signed it, make sure you understood it?
Yes, sir.
And you feel you had enough time to fully consider the matter before making this decision?
Yes, sir.
And since it's been a few days, or a couple of days since you signed it, is this still what you want to do?
Yes, sir.
And you're going forward with this plea agreement voluntarily?
Yes, sir.
All right, so the agreement states you're going to plead guilty to count 1, trafficking in a fentanyl-related compound, a 4th-degree felony under 2925.03A1 of the Ohio Revised Code, 4th-degree felony, and that you understand that the penalty for that could be between 6 and 18 months in prison, a fine of $5,000, and a license suspension of 6 months to 5 years. You understand that?
Yes, sir.
Facing any felony charges anywhere else?
No, sir.
Are you on community control, probation, parole, post-release control for a felony?
No, sir.
Under the law, if you're sentenced to prison for this offense, Mr. Jordan, upon completion of that, it is possible the adult parole authority will put you under post-release control for a period of up to 2 years. Under the terms they said, if they did that and they decided you had failed to comply, they could return you to prison to make you serve an additional period of up to half of your prison term for one or more violations. However, if you commit a new felony, then in addition, whatever sentence the judge in a new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that post-release control, whichever is greater. If that occurs, that has to be served consecutively sentenced in a new case. Do you understand that?
Yes, sir.
Right now, not required by law to sentence you to prison. Can impose what's called community control or probation, meaning instead of going to prison, you'd be supervised under a period up to a period of 5 years under terms set by the court by a probation officer. And if they felt you did not comply, they would file a written notice at the court, give you a copy. There would be a hearing. You'd be entitled to have an attorney. The outcome of that hearing was you failed to comply. Then at that time, the court could revoke your community control and then sentence you to 18 months, fine you $5,000. Do you understand that?
Yes, I do, sir.
All right. Also, if that were revoked because in part or whole of a conviction for a new felony and you received a sentence in that case, that sentence could be ordered to be served consecutively in this case. Do you understand that?
Yes, sir.
All right. Now, the charge of count 1 alleges that on or about February 6, 2024 in this county, you did knowingly sell or offer to sell a fentanyl-related compound, Schedule 2 controlled substance amount exceeds 1 gram less than 5 grams in violation of Section 2925.03A1. So that is the charge with the penalty I just described. You understand what it is you're charged with in that count, what the state said you did, when, where,
yes,
how they led you did it?
Yes, sir.
And have you discussed the nature of that charge, the evidence in the case, the possible legal issues in the case, the possible defenses you might try to raise in trial, possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with her advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir.
Now, on page 2, there's a little over 3 lines printed in bold and underlined that read as follows. Defendant will enter a plea of guilty to count 1. State will dismiss remaining counts. State and defense jointly recommend 12 months incarceration. Defendant agrees to cooperate fully with the task force. Defendant agrees to repay by money to the task force the amount of $350. Is that your understanding of the agreement?
Yes, sir.
Anyone promise you anything other than that to get you to plead guilty here today?
No, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, sir.
Now, you have certain constitutional rights you must understand before I can accept a plea of guilty from you. Your first right is you have a right to counsel, and that's Ms. Witt, who I appointed to represent you since you didn't have your own funds to hire an attorney. Her appointment wasn't simply to work the case out, excuse me, but to provide any defense that may be available to you under the law that you'd like her to provide. So if you decide you don't want to do this, that you want to defend against the charge, she'll continue to represent you, including in trial, if that's what you want. Do you understand that?
I do understand, sir.
Right now, under the Constitution and the law of Ohio, you have a right to have a jury trial on this charge in which 12 people you selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, they'd be instructed on the law, and that jury would decide by unanimous verdict, meaning all 12 would have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you did not want to plead guilty, you can waive, which means to give up in writing, the right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to confront the witnesses against you in open court and cross-examine them through your attorney. What that means is witnesses against you have to come into court and testify in front of you, your attorney, and anyone else may be present. After the prosecutor is done asking questions, your attorney can ask questions. That's called cross-examination, the purpose of which is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses that are not going to come in voluntarily, in your opinion, to testify, and your request, the court orders them to appear by a subpoena, and that makes them available to testify for you if you want them to, even though they don't want to be involved. And that's the same way the state's witnesses are forced or compelled to come in and testify against you. Do you understand that?
Yes, sir.
Under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to comment about it except in one situation. Should there be a jury trial and you not testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charge by proof beyond a reasonable doubt. What that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence in your own defense. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Originally, you pled not guilty, which denied the allegations in the indictment, denied you committed any crime, and exercised or invoked all the rights I just described. You change your plea to count 1 to guilty. That is the opposite of not guilty plea. It admits the allegation, admits that it's a crime, that you committed that crime, and that plea waives gives up all the rights I've described for you today, except the right to have an attorney. You always have a right to have an attorney no matter what your plea. With that exception, the plea of guilty waives gives up the right to a jury or court trial. Waives gives up your right to confront witnesses against you and cross-examine them through your attorney. Waives gives up your right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. And waives gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. Waives gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court. Finally, it waives gives up a right to file an appeal you think you may have had up until this point in the case. Now, should you be sentenced to the maximum sentence or under limited circumstances, an appeal could be filed. That would have to be filed within 30 days for sentencing to intervene filed. Do you understand all that?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the charge, the possible penalty?
No, sir.
You understand it?
Yes.
Have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
Any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
You understand?
Yes, sir.
And you understand the constitutional rights I've explained to you?
Yes.
All right, is there anything you'd like to speak to your attorney about before we go any further? If so, I can put you and her in the breakout room where it'll just be the two of you talking on screen. No one else will be able to see or hear you.
No, sir, I'm good.
Okay. Then is it your decision to go forward voluntarily and plead guilty to count 1 pursuant to the terms of the plea agreement?
Yes, sir.
And as to the charge, as that alleges that on or about February 6, 2024 in Huntington County, Ohio, you did knowingly sell or offer to sell a fentanyl-related compound, a Schedule II controlled substance amount that equals or exceeds 1 gram is less than 5 grams, in violation of Section 2925.03A1 of the Ohio Revised Code. Charge of trafficking a fentanyl-related compound, 4th-degree felony. How do you plead?
Guilty, sir.
All right. Court finds that on this date, open court, the defendant was advised of all of his constitutional rights, made a knowing, intelligent, and voluntary waiver of the same pursuant to Criminal Rule 11. The plea is accepted, order filed. Defendant is found guilty of count 1 as charged. Counts 2 to 4 are dismissed. Inasmuch as there's a stipulated agreement as to sentence, the court is going to go ahead and proceed with sentencing forthwith. All right, Ms. Collins, anything on behalf of the state?
Only what's contained within the plea agreement.
Ms. Witt? Jail time.
Yes, Your Honor. We also asked the court to follow the joint recommendation in meeting with Mr. Jordan. He's been extremely cooperative and upfront and accountable for his actions, and I believe has since been clean after this charge. So we do feel that the 12 months is adequate for his rehabilitation as well.
All right, Mr. Jordan, anything you'd like to say? All right, Mr. Jordan, anything you'd like to say?
No, sir.
All right, it's the order of judgment of the court that you be and are hereby sentenced to a term of 12 months of Correctional Reception Center, Oriole, Ohio. According to the sheriff, you were arrested on the 1st of October, is that correct?
Yes.
All right, so you'll be given 17 days of jail time credit. On completion of that prison term, Mr. Jordan, it is possible the adult parole authority will put you under post-release control for a period of up to 2 years. If they do, you'll be supervised by a parole officer of the terms they set, and if during that period of time they determine that you are not compliant, they can return you to prison and make you serve an additional period, up to half your prison term for 1 or more violations. But if your violation is a new felony, then in addition, whatever sentence you could receive on the new case, that charge could also include a sentence for committing that violation while under push release control, in this case, of 1 year, whatever time's left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to sentence a new case. You're also ordered to pay the court costs when judgment granted and execution is ordered. If you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets that you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, once you get out, you can do community service in this county and be given credit for each hour you worked, and an hourly rate set by the court each hour you work will reduce your judgment by that amount until paid in full. You're also ordered to pay the restitution of $350 Highland County Task Force. That'll be payable through the Highland County Victim Witness Restitution Escrow account. All right. Is there anything further from council?
No, Your Honor.
All right.
No, Your Honor.
Thank you. Is Mr. King coming back over for this, Mr. Fitch? Order. Are you there, Mr. Wallace?
We are here, and I'm not sure where the problem is.
All right. Is your client there with you?
My clients, all three of my clients are
All
here.
three of them are there? Okay. All right. There are two cases here that we're hearing jointly. Case number 24 CV 127 and CV 128. There we go. We have video now, Mr. Wallace. The plaintiff in both cases is David Boline. You're David Boline, appearing there with Mr. Porter.
Yes, sir.
All right. The defendant in case number 127 is Steve Howland, and he's represented by Bruce Wallace, who's appearing. And is Mr. Howland there with you?
He is, Your Honor.
All right. And then in case number 24 CV 128, defendants are Jody Burke, Kenneth Burke, and they're both there with you.
Jody
Okay.
and Kenneth.
All right, thank you. All right. The purpose of this hearing is a return on the report of the commissioner. In each case, it was the same commissioner. These are both actions for partition. The court appointed Commissioner Rick Williams, local realtor and appraiser. He filed his, where the writ was issued by the sheriff on the 17th, and it was filed on the 17th, actually, and it was returned on the 17th. and Mr. Williams signed it on the 10th. In case 24 CV 127, he appraised the same at $275, the premises therein. And in the 128 case, he appraised the premises at $135,000. All right, now, counsel, are there any objections to the report or wish to present any evidence, not today, but at a later time, if there's any objections to the report? Mr. Porter?
No objections, Your Honor.
Mr. Wallace?
No objections to the report.
All right. Now, the next step then is that the court issues an order to grant the parties the opportunity to elect to take the interest of the opposing parties. And so I usually give 14 days, and it'll probably be tomorrow, or if not Monday, before I get an entry filed, but whatever date I get it filed, it'll run from that date. That means that any party can purchase the interest of the other parties for the appraised value of that proportional share. The court does have a policy that there's a requirement that they present either deposit the cash or an irrevocable letter of credit, or whatever the equivalent of that is today. As I understand it, banking now, they don't use that word. They use something different, but it's something that would be deposited with the clerk and cannot be revoked to secure the payment. And if more than one party elects to take the interest in the same parcel, then that will require a public auction. Typically, it would be conducted by the sheriff, unless the parties request that the court appoint an auctioneer to do it, in which case I have generally done that. Usually they charge about 5 to 6% and put up an advertising cost of about between $1,000 and $2,000 per parcel, so there could be some marketing above and beyond the usual sheriff sale, which is only legal notice. And typically they do some advertising on their websites and paper, and mostly online, I think, to try to demonstrate or get more interest. So I don't need a decision today, counsel, but I'll file that entry unless the two of you have already discussed it and have an answer for me.
We do have an answer, but we will be having discussions in the next, within the 14 days, there will be discussion with Mr. Porter.
And if you decide you would like to have an auctioneer do it, I'll entertain a nomination, although I will say that some of the auctioneers have a little difficulty understanding that this is, when you do an auctioneer's and they have to give an auctioneer deed, they don't understand that. And I had some difficulties with one in a different case. And I just finally said, they said, well, we were told we couldn't do this. I said, well, if you don't want to do it, that's fine. I'll just get somebody else. So then whoever told them they couldn't do it apparently told them they could because they changed their mind. So in any event, if you give me, if you guys have an agreed person, I'll, as long as there's somebody that's willing to do it and understands what needs to be done, at the compensation that is usually permitted, then we'll do that. And if not, then I'll find somebody else. All right. Anything further from counsel?
No, Your Honor.
No, Your Honor.
All right. Thank you, gentlemen. Sorry about the delay. We got hung up with some technical difficulties here on our Zoom with the jail hearings, and it threw us off about a half hour. So sorry for the delay.
Thank you.
All right, case number 24-CR92, State of Ohio versus Corey Lee Fitch. Present on behalf of the state is Assistant Prosecuting Attorney King. Present on behalf of the defendant is Attorney Sarah Barger. Are you Corey Lee Fitch?
Yes.
All right, Mr. Fitch has charged with 2 counts, one of aggravated possession of methamphetamine and one of possession of cocaine, 5th-degree felonies. Matter before the court on a motion for intervention in lieu of conviction. I don't know if the attorneys have received these reports or not, but the report from REACH for tomorrow, which is where he was enrolled, indicates that he's been attending groups the past 2 weeks, but he's not engaged and did not participate during the group, and he slept through all the groups he attended. He did not take a urine analysis. And then I have another report from the probation department dated today that indicates that he has failed 3 drug tests while on pretrial supervision, was offered inpatient treatment, declined inpatient treatment. Says he did report this morning asking for residential treatment, and there is a STAR bed available on October the 30th. Were you aware of this information?
I was, Your Honor, yes.
You were?
Yes.
Okay, all right. So is it the intention to go forward with this?
He's still wanting to go forward.
Okay, all right. Well, Mr. Fitch, the charges you are facing are both felonies of the 5th degree, which carry a possible term of incarceration of 6 to 12 months each. Could be a total of 24 months. There's a fine also of $2,500 and a possible license suspension of 6 months to 5 years. Now, normally if a person is convicted of a crime by pleading guilty, they're sentenced. And then that makes them a felon. Sentence could be community control or probation, could be jail time, could be a prison sentence and fine or any combination. And once that occurs, there is a prison record. Now, there is a provision under the law that allows a person to go into treatment if they plead guilty, if they're in a certified approved treatment program, and the court finds that the offenses were committed in part or in whole due to a diagnosed substance use disorder problem, which I don't think there's any doubt about that with you. You do have that issue. Now, what happens then is you go through this treatment plan, and and one of the things that it includes is you have to remain drug and alcohol free for at least a year. And then you have to comply with other conditions of supervision through the probation department. Those conditions are not as serious or as numerous as if you were convicted and put on community control. Those are much more numerous and also more restrictive. Now, the advantage to you is that if you go through this program and complete it successfully, and you comply with the supervision conditions, which will include paying off the court costs and that type of thing, once that is reported back to the court, the case is dismissed, even though you pled guilty, because if you go into intervention, I don't sentence you. I just stop the case. It's called staying, which means it will stop the case pending a report over the next 2 years as to your progress. And if you're successful, the case is dismissed, and then we'll have a hearing and seal the record, and it'll go away out of the records completely. So that's the big advantage for you. And that's a big one, because you got 2 cases, you got 2 felonies here, and you're looking at 24 months possible time. Now, the disadvantage to you is that if you go through the program and you don't make it, then you don't get to come back and start over. You then come back for a sentencing. And at that time, now, in order for that to happen, this is the way it would work. Probation would file a written notice with the court saying, you know, Mr. Fitch is not complying, and here's why. You get a copy of that, then I would set a hearing and appoint an attorney. If you didn't have the funds to hire one, you would definitely be represented by an attorney. Then there has to be a hearing in which the state would have to present the evidence that proves that you've committed that violation. Now, if that happens, then your plea is accepted and you're found guilty, and then you are sentenced. And at that point, then you have a felony record. Now, at that time, it could be a sentence of incarceration of up to 24 months, could be a fine of up to $5,000, could be a license suspension of 6 months to 5 years, or any combination of those factors. Doesn't have to be, though. It could also be community control. Community control is probation, like I mentioned earlier, and it can be for up to 5 years. This program can also be 5 years, but I make it 2 years because I think that's sufficient time to determine if a person is going to be able to be successful. But if they don't make it, then 5 years is the maximum for probation. Basically, it's the same process, except as I explained earlier, there are more restrictions and they're much more restrictive. And again, the same process would happen if you failed to comply. There would be a notification filed, you'd get a copy, have a hearing, you'd be entitled to have an attorney, and if the outcome of that hearing was you failed to comply, then at that time the court could then sentence you to 24 months incarceration and fine you $5,000. Now, if that should happen, and if you should be sent to prison, then upon completion of that prison term, the Adult Parole Authority could put you under post-release control supervision for a period of up to 2 years under the terms they set, and you'd be supervised by a parole officer from the state at that time, and if they determine that you're not compliant, they could then return you to make you serve an additional period of time in prison of up to 9 months for any one violation, up to a maximum of half your prison term for all violations. But if you commit a new felony, then in addition, whatever sentence could be imposed in that new case, then you could be sentenced to an additional term of a year, whatever time is left on the period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. All right, do you understand all that?
Yes.
Okay. Now, the two charges in this case, the first one is that on or about October 13, 2023 in Highland County, Ohio, you knowingly obtained, possessed, or used a Schedule II controlled substance, to wit methamphetamine, in violation of Section 2925.11a of the Ohio Vice Code. And then count 2 alleges on or about October 13, 2023 in Highland County, Ohio, you knowingly obtained, possessed, or used a Schedule II controlled substance, to wit cocaine, in violation of Section 2925.11a. So those are the two charges against you with the penalties I've just discussed. Now, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, Your Honor.
You understand the possible penalties for those offenses?
Yes, Your Honor.
Now, have you discussed those charges, the evidence in the case, the legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, Your Honor.
Are you satisfied with her advice and competence in this matter?
Yes, Your Honor.
Now, or you probably have taken drugs recently.
What?
When's the last time you used? On the last day? Okay. Well, the reason I'm asking you, are you under the influence of any of those drugs right now, or do you understand what's going on?
Yes, I understand.
Your mind's clear enough to understand me and to tell me accurately what you're thinking. Thinking. All right. Has anyone threatened you in any way to make you plead guilty?
No, Your Honor.
Has anyone promised you anything other than being put into the intervention in lieu of conviction program to get you to do this?
Oh, yeah.
Okay. Now, do you hold any kind of a license or certification from a state governmental agency that regulates any occupation or profession in Ohio?
No, Your Honor.
All right, now, since this is your last chance to stand on a not guilty plea and defend, you must understand your rights before I can let you enter a plea of guilty. You have a right to counsel. Ms. Barger was appointed to represent you. Now, her appointment wasn't simply to try to work the case out, but to provide any defense that could be available under the law that you would like her to provide. So, if you decide that you do not want to do this, that you want to rather defend against the charges, then she'll still represent you and do that, including a trial if that's what you want. You understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to have a jury trial on these charges in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. Once they are selected, the evidence will be presented, and then they'd be instructed on the law. And that jury of 12 people would then decide by unanimous verdict, meaning that all 12 would have to agree, on whether the state proved your guilt on either or both charges. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you can waive in writing your right to have a jury trial. And that means that instead of a jury hearing the evidence, the judge would be the one who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right excuse me, to confront the witnesses against you and to cross-examine them through your attorney in open court. So what that means is that the witnesses against you have to come into this courtroom and testify in front of you and your attorney and anyone else that may be present. After the prosecutor's done asking questions, your attorney would ask questions. That's called cross-examination. And the purpose of that would be to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, Your Honor.
All right, now under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify for you, same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court will issue a court order called subpoena, and that would force those people to come to court to testify for you, even though they didn't want to be involved, which is the same way witnesses are forced to come in to testify against you for the state of Ohio. Do you understand that?
Yes, Your Honor.
Under the Constitution, Mr. Fitch, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't. You make a decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. And in fact, no one's even allowed to comment about the situation except once about that except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Now, Mr. Fitch, under the Constitution, you're presumed innocent of these charges until proven guilty by the state of Ohio on every essential element of each offense. What that means is the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence at trial to defend yourself. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of each offense by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
Now, originally you entered a plea of not guilty, which denied the allegations in the indictment, denied you committed any crime, and exercised all the rights I've just described. You change your plea from not guilty to guilty. That is a complete opposite of the not guilty plea. The guilty plea will admit the allegation in the indictment, admit that they're a crime, that you committed that crime. And that plea will waive or give up all of the rights I've just described for you, except the right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial, would waive or give up your right to confront witnesses against you and to cross-examine them through your attorney, would waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. It would waive or give up your privilege against self-incrimination because you're saying you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence because if you say you're guilty, that's what's used to find you guilty. And it would subject you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you may have had up until this point in the case. Should you be sentenced to the maximum sentence or of the certain limited circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all that?
Yes, Your Honor.
Are you a U.S. citizen, Mr. Fitch?
Yes, Your Honor.
All right. Now, do you have any questions about the process that we're going through here or what's going to be required?
No, Your Honor.
Do you have any questions about the plea agreement?
No, Your Honor.
You understand it?
Yes, Your Honor.
Have any questions about the constitutional rights I've explained?
No, Your Honor.
Understand that?
Yes, Your Honor.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, Your Honor.
All right, then is it, do you need to speak to your attorney before we go any further?
So I need to plead guilty.
If that's what you're saying, what
Well, is that plea agreement? Yep. No, Your Honor.
Is it your decision to withdraw your not guilty plea and plead guilty to the 2 counts pursuant to the terms of the agreement that we've just gone over?
Yes, Your Honor.
Okay. Then as to count 1, which alleges that on or about October 13, 2023 in this county, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit methamphetamine, violation of section 2925.11 of the Ohio Revised Code, a fifth-degree felony with the penalties I described earlier. How do you plead?
Guilty, Your Honor.
As count 2, which alleges on or about October 13, 2023, in Highland County, Ohio, you knowingly obtained, possessed, or used Schedule 2 controlled substance 2 cocaine, also in violation of section 2925.11a, Ohio Revised Code, a fifth-degree felony with the penalties I described earlier. How do you plead?
Guilty.
Thank you. Be seated. All right, I do have a question. We have a star bed available for Mr. Fitch on the 30th of October. That's 2 weeks from yesterday. Mr. Fitch, I have some serious doubt you can make it until then without getting deeper in trouble. What about him going into what do you call it, drying him out?
Your Honor, I scheduled the star bed because of his non-compliance and not being successful
Right.
in outpatient. However, I do have the option of an inpatient bed tomorrow. I can get him in residential at noon tomorrow. They could make that a temporary stay until the star bed.
Okay.
So either option.
And where would that be?
He could stay in residential from
Where-
tomorrow at noon until the star bed, or he could stay in residential.
Well, where's the residential?
TCC, they're sitting in May tomorrow at noon to pick up someone else.
All right. I think that's a better result here for him to go tomorrow as opposed to taking a chance of him in 2 weeks without using, because I don't think you can do it, Mr. Fitch. You don't think you can do it either. You haven't done it. So, Ms. Barker, you want to talk to him about that?
I actually discussed all this with him prior to court. Had a conversation even with him yesterday after I was notified by probation that he's been non-compliant and what was going on. Spoke with Mr. Fitch and told him he needed to figure out how to basically get it together. He had to do inpatient if it was necessary, and if the probation department had done an assessment and said it was necessary. At that time, he said he would go to inpatient, and this morning I was told he showed up and he did do an assessment and they were looking for a bed. So if it's possible to get him into inpatient so he can get the help that he needs, because he does need that help.
You want to report to the probation department at noon?
Yes, sir.
All right. Well, the court finds that the defendant's plea was entered knowingly and voluntarily pursuant to Criminal 11, and plea to each count is accepted. However, the court will not enter a finding of guilt at this time, but rather the plea will be stayed, and it is ordered that the defendant be put under community control under the Intervention in lieu of Conviction program. Conditions have been previously approved by the court under the supervision of the probation department for a period of 2 years. He successfully complete the intervention plan, and that includes a requirement you must abstain from using drugs for a period of, or alcohol for a period of 1 year, at least 1 year. You must comply with all the conditions the court has set for the probation department. You're to successfully complete the intervention plan and all other conditions of community control. You will be required to report to probation at 11 a.m. tomorrow. And that's when you be transported to TCC. Be required to successfully complete the Substance Use Disorder Program, which is abbreviated as SUD in your entry, at TCC, which is abbreviation for the Counseling Center, and aftercare, which probably is going to include transitional housing as well as some sober living for a period of time. So you'll need to report tomorrow by 11 a.m. down there. Now, in the event that you comply with all these conditions, Mr. Fitch, then the court will dismiss the charges against you and enter and set a hearing to seal the records, and then they will be sealed. If it's alleged you have failed to comply, as I indicated to you, there'll be a hearing after they give you a written allegation of that. have an attorney to represent you. And if the outcome of that hearing is you fail to comply, then at that time, the court could sentence you to 24 months incarceration and fine you $5,000. You'll also be required to pay the court cost plus a $50 deposit for the sealing fee. Now, Mr. Fitch, don't mess this up. You better just stay with, is that your mother there? Or friend, whoever it is?
Fiance.
Okay. You need to keep him under control, because if you screw this up, you go out and get high and you might end up in the hospital and die, or you could end up getting arrested again. And if that happens, all bets are off, because you're going to come back in here. Because if you get charged with a crime, that's also a violation. It's one of those conditions of the program. So you need to try to be cold turkey tonight. I don't know what it's going to take to keep you from using. At least get yourself there tomorrow in one piece at 11 a.m.
Okay, Your Honor.
All right. All right. Anything further, counsel?
No, Your Honor.
All right. Thank you.